Thank you so much for the kind and generous introduction, and thank you for the warm welcome. It's truly my great honor and pleasure to be with you. Everything changed in the United States Supreme Court on Saturday, February 13th, when Justice Antonin Scalia died. From 1971, when Richard Nixon's third and fourth justices were confirmed for the Supreme Court, until February 13th, there always were at least 5 and sometimes as many as 8 justices who were appointed by Republican presidents. Now, of course, there are 4 justices on the bench who are appointed by Republican presidents: Chief Justice John Roberts, Justice Anthony Kennedy, Clarence Thomas, and Samuel Alito. There are 4 justices appointed by Democratic presidents: Justice Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan. I think that all of the controversy concerning the appointment and confirmation of Chief Judge Merrick Garland can be understood, and everyone regarding this is a truly pivotal seat on the United States Supreme Court. Now, I should pause for a moment of disclosure and tell you that I've known Merrick Garland since the late 1960s, when we were competitor high school debaters in the Chicago area. We also went to law school together. He was a year ahead of me in law school. In fact, the morning that President Obama nominated Chief Judge Garland for the Supreme Court, my oldest son called me and said, "You've known him a long time. What do you think of him?" And I said that I think that Merrick is a brilliant man. He's truly a decent person. And I said to my son, look at it this way. Merrick Garland is a Jewish man in his early 60s who had Eastern European grandparents. He grew up in the Chicago area. He was a high school debater. He went to Harvard Law School. I could also say he is about 5'7". He has gray hair and wears glasses. What's not to like about all of that? I think there's a real chance that if Hillary Clinton is elected president in November, Senate Republicans will choose to confirm Merrick Garland in December. Merrick Garland will be 64 years old then. By all accounts, he's moderate. And I could imagine Senate Republicans deciding that they'd rather have a 64-year-old moderate than take their chances on a much younger liberal. But this isn't the only vacancy that the next president is likely to be able to fill. Did you know that since 1960, 78 years old is the average age which a Supreme Court justice has left the bench? There are 3 justices right now on the Supreme Court who are 78 or older. Ruth Bader Ginsburg turned 83 on March 16th of this year. Anthony Kennedy turned 80 on July 23rd. Stephen Breyer turned 78 on August 15th. This then means that the next president, especially if he or she serves for 2 terms, is likely to have 3, and depending what happens with Justice Scalia's seat, 4 vacancies to fill on the Supreme Court. What I want to talk about then is what's it likely to mean to replace 2, 3, even 4 justices on the court in the next 8 years. What I want to suggest for you is that literally every area of constitutional law, all areas concerning our rights, virtually every area of federal statutory law, are likely to be affected by this. To illustrate, I want to focus relatively quickly on 7 examples to show you how much this election is likely to mean with regard to the composition of the Supreme Court. And then I'll save some time for questions. I'll use these examples and go through them alphabetically, so there's no bias reflected in terms of their importance. You can judge that for yourself. So, starting at the top of the alphabet, abortion. On the current court, there are 3 justices who believe that Roe v. Wade is wrongly decided and surely would vote to overrule it if only they had 4th and 5th votes. That's Chief Justice John Roberts and Justice Clarence Thomas and Samuel Alito. It's important to keep in mind that all 3 of these justices are still in their 60s, so are likely to be on the court for a couple of more decades. On the other hand, there are 4 and maybe even 5 justices who will strongly protect women's right to abortion. There's no doubt that Justices Ginsburg, Breyer, Sotomayor, and Kagan are strong supporters of women's right to choose. Justice Kennedy has been more inconsistent over the course of his career. When he first voted in an abortion rights case in 1989 in Webster versus Reproductive Health Services, Justice Kennedy joined with the two dissenters from Roe versus Wade, William Rehnquist and Byron White, in calling for it to be overruled. But 3 years later, in Planned Parenthood versus Casey in 1992, Justice Kennedy joined in a joint opinion with Justice O'Connor and Souter to reaffirm Roe versus Wade. The most recent Supreme Court decision about abortion was on June 27th of this year, Whole Women's Health versus Hellerstedt. It involved a Texas law, HB 2. You might remember Wendy Davis leading an unsuccessful filibuster against it on the floor of the Texas State Legislature. It imposed two restrictions with regard to abortion. One said that in order for a doctor to perform an abortion, he or she had to have admitting privilege to a hospital within 30 miles. Generally, these hospitals would not give the doctors admitting privileges. Sometimes it's because the hospitals were religiously affiliated. Often it's because the hospitals required that in order for a doctor to have admitting privileges, he or she had to admit a minimum number of patients a year. Abortion is such a safe procedure, rarely would the doctors need to admit patients. The other provision said that in order for abortions to be performed at a facility, it had to have surgical quality facilities. It had to have hallways big enough for 2 gurneys, had to have the HVAC facilities used in hospital operating rooms. Before Texas adopted this law, there were 40 facilities in Texas where abortions were performed. When the law passed, 20 of those facilities closed. The parties did not dispute before the Supreme Court that if it had upheld the statute, all but 7 or 8 facilities in the whole state would have been closed. On Monday, June 27th, in a 5-3 decision, the Supreme Court declared the Texas law unconstitutional. Justice Breyer wrote, joined by Justice Kennedy, Ginsburg, Sotomayor, and Kagan. Anthony Kennedy came on the Supreme Court in February 1988. This is only the second time in all of these years that he's ever voted to strike down a restriction on abortion. The prior one was in 1992 in Planned Parenthood versus Casey, where Justice Kennedy joined the majority in striking down a part of a Pennsylvania law that said before a married woman can have an abortion, she would need to give notice to her husband. Justice Breyer, writing for the court, said, "It's for the judiciary, not for the legislature to determine whether the burden in terms of access to abortion is justified in terms of the benefit in protecting women's health." The court said there's no evidence that this law would do anything to protect women's health. There's no need for a doctor to have admitting privilege at the local hospital. If a woman was having complications and was taken there, the doctors there would provide treatment. No need for surgical quality facilities because no surgical procedures are being done. There's no need for hallways big enough for 2 gurneys. Gurneys weren't used. Had Justice Kennedy voted, as in so many prior cases, with the conservatives to uphold the restriction on abortion, then the Texas law would have gone into effect. The decision of the United States Court of Appeals for the Fifth Circuit upholding law would be affirmed by an evenly divided court. So that's why I say on the current court, you have 4 justices who will consistently vote to strike down abortion restrictions. You have Justice Kennedy, who did so here, and 3 justices vote to overrule Roe versus Wade. So what does it mean with regard to the coming election? If Donald Trump is elected president and gets to replace 2, say, among the 4 justices that I mentioned, then it seems clear there will be 5 votes to overrule Roe versus Wade. And as recently as night before last, Donald Trump said that's exactly what he wants to do. It would then be left to each state to decide how and whether to regulate abortion. Slightly less than half the states already have laws on the books that would prohibit all or almost all abortions. These laws would immediately go into effect in those states. It's likely that a number of other states would adopt laws prohibiting all or almost all abortions. Of course, there are other states, like California, which will not prohibit abortion. What that will then mean is, for women who have the economic means, they'll be able to travel to states where abortion is legal. It's poorer women and teenagers who won't be able to. Before New York became the first state in this country to legalize abortion, abortion was already legal in England. 1/4 of all the abortions in England were performed on American women. It was not poor women, it was not poor teenagers without means who were traveling to England for abortions. The effect of overruling Roe v. Wade will have a particularly harmful effect with regard to the poorest in our society, and especially teenagers. My second issue, alphabetically, is affirmative action. The Supreme Court decided its most recent affirmative action case on Thursday, June 23rd of this year. The case was Fisher v. University of Texas at Austin. It involved a University of Texas program that said that 75% of each entering class would be accepted by admitting the top 10% from high schools across the state. For the other about 25% of the class, they did an individualized review of every application. For each applicant, an admissions score was calculated. The score is the sum of two numbers. One is called the Academic Achievement Index. That's the student's grades and test scores. The other was called the Personal Achievement Index. A number was arrived at by grading 2 essays required in the application for admission and looking at 7 factors. One of them is what the student would contribute to diversity at the University of Texas. The regents felt that they'd done exactly what the Supreme Court prescribed in its 2003 decision in Grutter v. Bollinger. It used race as one factor among many in admission decisions to benefit minorities and enhance diversity. Abigail Fisher, a white woman, applied for the University of Texas in 2008. She was denied admission. She wasn't in the top 10% of her high school class. She wasn't admitted through the individualized review of her application. She filed a lawsuit when she was denied admission, saying that the use of race violated equal protection. She enrolled in Louisiana State University, from which she graduated in 2012. I can only guess as to the reaction of her alma mater, Louisiana State, in hearing Abigail Fisher say she was terribly injured in having to go to Louisiana State University rather than her preferred school at the University of Texas. On Thursday, June 23rd, the Supreme Court, in a 4-3 decision, upheld the University of Texas affirmative action program. Justice Anthony Kennedy wrote for the court, joined by Justices Ginsburg, Breyer, and Sotomayor. Justice Elena Kagan was disqualified from participating because she'd been involved in the case when she was Solicitor General of the United States. Justice Samuel Alito wrote a vehement 52-page dissent, joined by Chief Justice Roberts. Justice Thomas wrote a separate dissent. Much like comes to abortion, there are 3 justices on the current court who will vote to declare all affirmative action unconstitutional: Chief Justice Roberts and Justice Thomas and Alito. In fact, in 2007, in Parents Involved in Community Schools for Seattle School District No. 1, Chief Justice Roberts wrote an opinion saying that the Constitution requires that the government always be colorblind, and any consideration of race violates the Constitution. If Donald Trump gets to replace 2 of the justices who now favor affirmative action, there'll be 5 to declare all affirmative action programs unconstitutional. Much like abortion, I think there are 4 justices who are strong supporters of affirmative action: Justice Ginsburg, Breyer, Sotomayor, and I also think Justice Kagan, though she didn't participate in this case. Justice Kennedy, though, is harder to talk about with regard to affirmative action. As I mentioned, Anthony Kennedy came on the court in February 1988. From then until June 23rd, not once did Anthony Kennedy vote to uphold an affirmative action program. Not in education, not in contracting, not in employment. When Anthony Kennedy first participated in an affirmative action decision, it was Metro Broadcasting versus FCC in 1990. He likened affirmative action to apartheid and said that he regarded the Constitution as requiring the government always be colorblind. Anthony Kennedy has clearly shifted his views over time. If Hillary Clinton gets to replace these justices, I think it's clear there'll be a majority to continue to allow affirmative action for years and decades to come. My third example is from a non-constitutional area, but it's one that affects literally all of us, and that's arbitration. In recent years, the Supreme Court, in a series of 5-4 decisions, has aggressively enforced arbitration clauses, even in form contracts, even on no more than the back of an employment application. Let me mention one famous case here, AT&T Mobility versus Concepcion. AT&T advertised that it would give free cell phones to those who signed up for its service. The Concepcions, a married couple, went to sign up for the service. They, like all of us, had to sign an agreement. They, probably like most of us, didn't read the agreement they were signing. There was a clause in it that said if they had any dispute with AT&T arising out of the cell phone service, that they would have to go to arbitration. They couldn't file a lawsuit. The Concepcions were surprised when they got their first monthly statement to see that it had charged for $30.80 in sales tax. They felt since AT&T was promising free cell phone service, AT&T should have to absorb this cost. They wanted to be part of a class action suit against AT&T for fraud. But AT&T invoked the small print from the form that said if there was any dispute, it would have to go to arbitration. There's a 1925 federal statute called the Federal Arbitration Act. It says arbitration clauses in contracts in interstate commerce shall be enforced unless they're irrevocable under state law. The California Supreme Court, in the Discovered Bank case, said that arbitration clauses in routine consumer contracts are not enforceable in California. The California Supreme Court called them contracts of adhesion, contracts where there's really no bargain for exchange. The Federal Court of Appeals ruled in favor of the Concepcions, saying this is a contract that would not be enforceable under state law. The Supreme Court, in a 5-4 decision, reversed. Justice Scalia wrote for the court, joined by Chief Justice Roberts, Justice Kennedy, Justice Thomas, and Justice Alito. Justice Breyer wrote the dissenting opinion, joined by Justice Ginsburg, Sotomayor, and Kagan. Justice Scalia talked about the evils of class action suits. He spoke about class action suits have a terrorizing effect on business, forcing them to settle non-meritorious claims. He said the arbitration clause would be enforced and the Concepcions would have to go to individual arbitration. They couldn't bring a class-wide arbitration. Justice Breyer, in his dissent, said, be clear about what this is going to mean. It's not going to mean thousands or millions of separate claims against AT&T. It's going to mean no claims against AT&T. No one's going to sue or go to arbitration for $30.80. Justice Breyer said, we need class action suits for situations like this, where a large number of people each lose a small amount of money. In other recent cases, the Supreme Court likewise has strictly enforced arbitration clauses to keep injured people from the day in court. The reason I mention this is that arbitration clauses are increasingly ubiquitous. They're found in consumer contracts, like in this case, they're found in employment contracts. They're even found in medical contracts. Not long ago, I went to see a new eye doctor for the first time. The receptionist gave me a big stack of papers to fill out. In the middle was a form that I was asked to complete, where I signed it, I agreed that if any claims against the doctor arising out of the treatment, I could not sue the doctor, but would have to go to arbitration. I asked the receptionist if the doctor would still see me if I didn't sign the form. She said she didn't know. Nobody ever asked her that question before. The doctor did see me, but I've now heard from so many people of doctors who will not see patients unless they sign arbitration clauses. Around the same time, I bought a new Dell computer. You should know, in order to use a new computer or even an iPad for the first time, you have to click that you've read the terms and agree to them. I usually just click agree and use the machine. For the iPad, the terms are 46 single-spaced pages long. But I decided for my new computer to look to see if there was an arbitration clause. Sure enough, there was. There was a clause that said if any dispute with Dell arising out of the computer, I could not sue them in court, I'd have to go to arbitration. I wrote Dell a letter saying I did not agree to that clause, and by opening the envelope of my letter they agreed, I could sue them in court if we had a dispute. Dell did not write back, and the computer still sort of works. All of these recent arbitration cases were 5-4, so the current court, without Justice Scalia, is split 4-4. If Hillary Clinton replaces Antonin Scalia and some of the other justices, I think it's clear that these cases will either be overruled or at least narrowed. I think if Donald Trump wins and gets to replace Justice Scalia and other justices, this will be the law and probably even increased into the future. So my fourth example is campaign finance. Everyone in this room is familiar with the Supreme Court's decision in 2010 in Citizens United versus Federal Election Commission. There, the Supreme Court reversed a 7-year-old precedent and held that corporations have the right to spend unlimited amounts of money from their corporate treasuries to get candidates elected or defeated. Prior to Citizens United, corporations could spend money in election campaigns, but they'd have to create a political action committee to raise and then to spend the money. What Citizens United did in overruling the 2003 decision from McConnell versus Federal Election Commission was strike down a provision of the McCain-Feingold Bipartisan Campaign Finance Reform Act and say that corporations had the same right to spend unlimited amounts of money as individuals in election campaigns. But what's often forgotten, and certainly wasn't mentioned in the debate between Donald Trump and Hillary Clinton, is there have been a number of other recent Supreme Court cases striking down campaign finance laws. All of these, too, have been 5-4. Let me mention a more recent case from the Supreme Court. It's a case called Arizona Free Enterprise Club versus Bennett. I've long believed that one of the solutions to the evils of money in election campaigns is public funding of elections. The Arizona legislature had a major scandal. Arizona voters then adopted a law to create a public funding scheme for those who were running for statewide office and for the Arizona legislature. No candidate for office was required to take public funding of his or her election. But if a candidate chose public funding, there would be certain conditions along with it. For example, the candidate would have to participate in political debates. The concern always with public funding is, what if one candidate takes public funding and the other doesn't, and the other spends much more than the public dollars allotted? The Arizona law tried to deal with this by saying, if one candidate takes public funds and the other doesn't, and the one who doesn't spends more than the amount of public money, the number of public dollars will increase, but up to a capped amount. The Supreme Court declared this unconstitutional in a 5-4 decision, split along the same ideological lines that I've referred to repeatedly. Here, you have Chief Justice Roberts writing for the court, joined by Justice Scalia, Kennedy, Thomas, and Alito. Justice Kagan wrote the dissent, joined by Justice Ginsburg, Breyer, and Sotomayor. Chief Justice Roberts said that when the state is increasing the public dollars, it's discouraging others from spending money. That discouraging is a chilling of speech, and it violates the First Amendment. Justice Kagan wrote a compelling dissent. She said, the Arizona law doesn't restrict anyone's speech. The Arizona law just provides more money to candidates taking public dollars if the other side spends greater than the public allotment. She said, if you accept the premise of Citizens United, that spending money in elections is speech, this is leading to more speech. This shouldn't violate the First Amendment. I think that if Hillary Clinton is elected president, if Merrick Garland and another Democrat replaces Justice Scalia, some of these other vacancies are filled by Democratic nominees, the Supreme Court will reconsider these decisions. I think the court is very likely to overrule Citizens United and say it was an aberration departing from a 7-year-old precedent. And certainly Hillary Clinton has been clear in her speech at the Democratic Convention in the debates that she wants justice to overrule Citizens United. On the other hand, if Donald Trump is elected president, Justice Scalia will be replaced by somebody, same views, other vacancies we fill by justices with those views. And then, of course, Citizens United will survive. In fact, I think the Supreme Court is then likely to strike down other restrictions on campaign finance, like the federal law that says that corporations cannot directly contribute money to political candidates. My fifth example is the death penalty. I believe there are 4 votes on the current court to declare that the death penalty is inherently cruel and unusual punishment in violation of the Eighth Amendment. In June of 2015, Justice Breyer said this explicitly in a dissent that was joined by Justice Ginsburg. The case was Glossop versus Gross. It involved whether or not the protocol for lethal injections constituted cruel and unusual punishment. The court, 5-4, rejected the constitutional challenge to the protocol that's used for lethal injections. Justice Alito wrote here, joined by Chief Justice Roberts and Justice Scalia, Kennedy, and Thomas. Justice Breyer, in a dissent, urged the court to ask for new briefing and argument on the question of whether the death penalty is inherently unconstitutional. At some length, he presented the arguments why the death penalty is unconstitutional. He said there's too great a risk of executing innocent people because of wrongful convictions. He presented the statistics of people who had been sentenced to death and later exonerated. He said the death penalty as it's carried out in the United States is so arbitrary, so capricious, as to be cruel and unusual punishment. He said there's no evidence that the death penalty deters crime, whereas other benefits. I believe if there was a 5th vote to declare the death penalty unconstitutional, Justices Sotomayor and Kagan would be with Justices Breyer and Ginsburg. Now, I do not believe that Merrick Garland will be the 5th vote to declare the death penalty unconstitutional if he's confirmed for the court. All of the examinations of his record as a judge on the D.C. Circuit indicate that he tends to be fairly conservative on criminal law and criminal procedure issues. He's a former federal prosecutor, former deputy assistant attorney general in the criminal division, and I think in many areas Merrick Garland will be more conservative than Justice Scalia when it comes to criminal procedure and criminal law. But I think if Hillary Clinton is elected and gets to replace, say, Justice Kennedy, as well as some of the other justices, I think there will be a majority to declare the death penalty unconstitutional. Obviously, if Donald Trump wins and gets to replace Justice Scalia and other justices, the death penalty will continue to be a part of the American criminal justice system. My 6th example is guns. The language of the Second Amendment is an enigma. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. From 1791, when the Second Amendment was ratified, until June of 2008, never did the Supreme Court declare unconstitutional any federal, state, or local gun control law. Not once. What the Supreme Court said, in its relatively infrequent decisions on this topic, is that the Second Amendment means what it says. It's a right of people to have guns for the purpose of militia service. In June of 2008, the Supreme Court decided District of Columbia versus Heller, a case that was mentioned in the debate night before last. It involved a 32-year-old District of Columbia ordinance that prohibited private ownership, possession of handguns, and also imposed restrictions on long guns. The Supreme Court, in a 5-4 decision, declared this unconstitutional. Justice Scalia wrote the opinion for the court, joined by Chief Justice Roberts, and Justice Kennedy, Thomas, and Alito. Justice Stevens wrote a dissenting opinion. Justice Breyer wrote a dissenting opinion. The other dissenting justices joined. Justice Scalia, for the first time in history, said, the Second Amendment is a right of individuals to have guns, at least in their homes, for the sake of security. Now, the court was clear this is not an absolute right. The court said the government could regulate who has guns, like keeping people with a felony conviction or a history of serious illness from having guns. The government can regulate where people have guns, such as having guns near schools or airports. The government can regulate the type of guns people have, such as keeping people from having bazookas. But the court unequivocally said that the Second Amendment is a right of individuals to have guns in their homes. It's not limited to possessing firearms for malicious service. 2 years later, in McDonald versus City of Chicago, the court declared unconstitutional a Chicago ordinance that prohibited the possession of guns, including in the home. That, too, was a 5-4 decision. I'm not sure when views on guns came to be so defined by ideology and political party affiliation, but there's no doubt that conservatives tend to favor gun rights, liberals tend to favor gun control. I think that if Merrick Garland or a Democrat replaces Justice Scalia, if Hillary Clinton fills other vacancies on the court may well reconsider and even overrule District of Columbia versus Heller. Certainly will not extend it. On the other hand, if Donald Trump is the next president and replaces Justice Scalia and replaces the other justices, he's made clear that he wants to appoint justices who will very aggressively enforce the Second Amendment, and I think many laws regulating guns in the United States we declared unconstitutional. My seventh and final example is separation of church and state. This refers to a provision in the First Amendment that says that Congress shall make no law respecting the establishment of religion. In 1947, all 9 justices on the Supreme Court said that this can be understood through a metaphor coined by Thomas Jefferson. He said there should be a wall that separates church and state. This idea of a wall separating church and state wasn't invented by liberal law professors or even by the current Supreme Court. It was Thomas Jefferson who used this language. I think the idea of a wall that separates church and state is the notion that our government should be secular. The place for religion is in the private realm, in our daily lives, our churches, our synagogues, our mosques, our homes, even our businesses. And so, following this idea, there should be a wall separating church and state. The Supreme Court over the last several decades has said that prayer in public schools, even voluntary prayer, is unconstitutional. The ability of the government to place religious symbols on government property is restricted. The government is limited in what it can do in giving aid to parochial schools. But over recent years, the conservative justices on the court have explicitly rejected the notion of a wall that separates church and state. They believe that we should accommodate religion into government and government to supporting religion. Their view, often stated, is that the government violates the Establishment Clause only if it literally establishes a church or coerces religious participation. For them, nothing but the government literally establishing a church or coercing religious participation would violate the Establishment Clause. In March of 2005, I argued a case in the Supreme Court, Van Orden versus Perry. It involves a 6-foot-high, 3-foot-wide 10 Commandments monument that sits directly at the corner between the Texas State Capitol and the Texas State Legislature. My client, Thomas Van Orden, brought the lawsuit claiming that to put religious scripture at the seat of state government violates the Constitution. At the oral argument, Justice Kennedy said to me, with real hostility in his voice, if your client doesn't like the 10 Commandments monument, why doesn't he just look the other way? My answer, of course, was that a constitutional violation cannot be excused by ignoring it. Also, there'd be no stopping point. Then a city could put a large Latin cross atop City Hall and say, if you don't like it, look the other way. Well, because of changes in the court, up until February 13th, there were 5 justices who took this accommodationist approach. The last case that the Supreme Court dealt with about the Establishment Clause was 2 years ago, Town of Greece versus Galloway. Town of Greece is outside of Rochester, New York. It's about 100,000 people. For many years, every month, the town board invited a Christian clergy member to deliver a prayer. There were only a few months after a complaint were invited other than Christian clergy members. And almost every month, The prayer was explicitly Christian in its content. A challenge was brought. The United States Court of Appeals for the Second Circuit said, this is the very essence of the establishment of religion, for the town to invite only Christian clergy to an official function and have them deliver explicitly Christian prayers. But the United States Supreme Court reversed 5-4. Justice Kennedy wrote the opinion for the court, joined by Chief Justice Roberts, Justice Scalia, Thomas, and Alito. Justice Scalia and Thomas had a separate opinion. Justice Thomas wrote it and said that the government at most violates the Establishment Clause only if it legally coerces religious participation. Now, the court is split 4-4 on whether there should be a wall that separates church and state. I believe that if Merrick Garland is confirmed to replace Justice Scalia, there'll be 5 justices to enforce the wall that separates church and state. If Hillary Clinton is elected president, there'll be a clear majority to do so. If Donald Trump places Antonin Scalia, if he fills the other vacancies, then I think there'll be a majority for the view that the government violates the Establishment Clause only if it literally establishes a church or coerces religious participation. Why does this matter in our daily lives? It goes to things like, will voluntary prayer in public schools be allowed? When can the government put religious symbols on government property? What kind of aid can the government give to parochial schools? I've mentioned just 7 examples. There's so many others that I could talk about. The simple reality is that what the Supreme Court does affects all of us, often in the most important, the most intimate aspects of our lives. And so that's why I believe whether you see yourself as Democrat or Republican, whether you identify as a conservative or as a liberal, there should be no issue more important in the coming presidential election than who's likely to fill these 3 or 4 seats on the United States Supreme Court in the years to come. Thank you. Thank you.
Thank you, Dean Chemerinsky. I have told my class this morning that when I grow up, I want to be Erwin, and now you know why. He's a remarkable man, remarkable scholar with prodigious energy. We have some time for some questions,
Thank you.
Please wait for a microphone to come to you. Right up here, please.
I'd be interested in thoughts on the refusal to consider an approach, because the discussion now is going from beyond 10 months to a couple of years till there's the next congressional election. If the Senate's lost, a chance to put it off and get another majority, that seems to violate the social contract, but there doesn't seem to be a whole lot to stop it.
What's occurred since Chief Judge Merrick Garland was nominated is unprecedented in American history. 24 times in the past, a president has nominated somebody for the Supreme Court in his last year in office. In 21 of 24, the individual has been confirmed. In 3, the Senate took action but did not confirm the individual. This is the first time in history that a Senate has ever said, we're not going to hold hearings and we're not going to have a vote before the election. Merrick Garland now has gone longer than any nominee for the Supreme Court in history without a Senate action. Earlier this week, Arizona Senator John McCain said that he expected that if it's a Republican Senate, it will reject any nominee put forward by Hillary Clinton. This then raises the specter that we could go 2 or maybe 4 more years if there's a Republican Senate with only 8 seats on the Supreme Court. I believe that one branch of government violates separation of powers if it keeps another branch of government from carrying out its constitutional duties. The Supreme Court can't carry out its constitutional duties when it has only 8 justices. One of the most important things that the Supreme Court does is make sure that the Constitution and federal law has the same meaning in all parts of the country. That's why the Supreme Court looks to see when there's disagreements among the lower courts in deciding whether to take a case. But if the Supreme Court splits 4-4, that leaves in place lower court decisions that conflict with one another. The court's not performing its constitutional function. And yet I believe there is nothing that can be done to force the Senate now or ever to take a vote or confirm a nominee. I come to the same conclusion you do. I think this is one of so many places where the Constitution assumes the good faith of those who govern us. It assumes that the president will nominate, the Senate will approve or reject. And so my hope is that John McCain is just wrong, that even if there's a Republican Senate, Hillary Clinton can nominate somebody who they find acceptable. And my guess is it will be, if Hillary Clinton wins and the Republicans don't confirm Merrick Garland, I think Hillary Clinton, if it's a Republican Senate, will renominate Merrick Garland because he's, by all accounts, moderate, and I don't think she'd want to invest the political capital in a confirmation fight. I think if it's a Democratic Senate, things could be different.
Okay. Right up here, Bob.
Trying to get up without that. My comment is more of a comment than a question. As a lawyer, I've come across almost all 7 of what you're speaking about, and it was very interesting. But, you know, the arbitration clause is so hard for those of us who operate in the law to make any inroads into changing it at all. For instance, I was one of those people that believed AT&T when they told me they'd give me a free phone if I changed. But they wouldn't answer the phone, or else they send you out to 17 different people, and then pretty soon they hang up on you. I finally wrote a letter to the president of AT&T and said, shame on you. You know, you do this, and then you manage to avoid us all to the point to where we give up and we don't get the phone. I got the phone. I didn't look to see if they charged me tax on my, but I mean, they finally sent me a phone. So, you know, I kept track of all these numerous Jose and Marie.
Sure.
But
sure. Well, let me make clear. I have no objection to arbitration as a method of dispute resolution when both of the parties choose they want to be in arbitration. What I object to is a form contract where there's a little clause in fine print that says there has to be arbitration, and it's imposed by one side, like AT&T. There's a previous Supreme Court case back in 2001, Circuit City versus Adams, where a guy filled out a job application for Circuit City, and on the back of the job application in fine print was, if in any dispute with Circuit City, he'd have to go to arbitration, he couldn't go to court. He wanted to sue them for employment discrimination, and the Supreme Court ruled 5-4 that the language on the back of the employment application kept him from doing so. That's not a bargain for exchange. That's not a meaningful contract in any sense of the word.
well, I do a lot of construction law, and the AIA standard contract has an arbitration form in it, and I've just sat here and thought, I hadn't thought of that argument, so thank you.
Thank you.
Bettina? We'll need a mic for you, yeah.
The thing that bothers me about Merrick Garland is that he's another Jewish person who went to an Ivy League school, and there's such a lack of that kind of diversity on the court. Is that something to be concerned about, or does it concern you? What'll make a difference?
If Hillary Clinton should call me, and she won't, and offer me a seat on the Supreme Court, I will not decline on the ground that I am of the same demographic as Merrick Garland. This is an incredibly intellectually talented court, and yet, in so many ways, there's a stunning lack of diversity. All 8 of the justices, and I can include the most recent, Justice Scalia, and make it 9, went to Harvard or Yale Law School, except Justice Ginsburg did her second 2 years at Columbia after her husband graduated from Harvard Law School and took a job in New York. When Justice Scalia was on the court, it would be possible to say that every borough in New York except Staten Island had a justice who grew up there, but only 2 justices grew up west of the Mississippi, and that was Justices Breyer and Kennedy, and only 1 was appointed from west of the Mississippi, Justice Kennedy. I'm particularly concerned about the lack of justices who have trial-level experience. On the current court, only Justice Sotomayor was ever a trial judge. And I think the court is hindered in many of its decisions by not having justices who understand what goes on at the trial court level. The court that decided Brown versus Board of Education in 1954 did not have a single justice who had been a federal court of appeals judge. They had been things like Governor of California, Earl Warren, Senator from Alabama, Hugo Black, head of the Securities Exchange Commission, William Douglas, Attorney General Robert Jackson, Harvard Law Professor Felix Frankfurter. On the current court, 7 of the 8 justices were Federal Court of Appeals judges before going on the court. I once ran for elected office in the city of Los Angeles. It's an incredibly humbling experience to run for elected office. I remember saying to my wife the morning of the election, you know, I might get just 2 votes. And she looked at me and said, why are you so presumptuous to think you're going to get a second? It's a true story. I think it's good to have elected officials and people who have been elected on the court. Sandra Day O'Connor was the last one to fit into that category. I never want to see religious tests for who's on the Supreme Court. I wouldn't want Merrick Garland or Erwin Chemerinsky to be excluded or chosen on account of religion, but I do always want to make sure that it's a court that's as diverse as possible. So I hope that Hillary Clinton, or for that matter Donald Trump, will pick from graduates of other law schools. I particularly think that he should pick somebody who went to the University of Arkansas Little Rock School of Law and also the University of California Irvine School of Law. I think he should pick from a wider geographic area, and I hope also that he'll pick people who really have much more in the way of trial-level litigation experience.
And if the next president has multiple picks, then UALR and UC Irvine together.
We got it.
We have time for one last question.
Hi, my name is Nick Stevens. I'm a first-year student here at the Clinton School. My question is about the separation of church and state issue. Here in Arkansas, there's been a lot of justification around having the 10 Commandments at the Capitol surrounding the historical argument that our laws are historically based on these laws and that sort of thing. How far do you think that argument will hold up?
I see no objection if the 10 Commandments is truly a part of historical display with regard to lawgivers. When you go to the United States Supreme Court room, there is a frieze that runs around the top of the room that has such things as Hammurabi's Code, Moses, all the way through to relatively recently. And I have no problem with that. If they want to have a display that has many different lawgivers, and the 10 Commandments is one, it's no problem. What's different about the Texas case, and I know nothing about the Arkansas situation, at Texas, it was a single monument that sits right at the corner of the Texas State Capitol and the Texas Supreme Court. There were 22 other monuments on the grounds of the Texas State Capitol, but none had anything to do with law-giving or religion. The 10 Commandments comes from Scripture. And one of the things I learned in litigating this case is there is not one version of the 10 Commandments. That the Protestant religion has its version, the Catholic religion has its version, the Jewish religion has its version, and the differences are quite significant in terms of theology. For the government to pick one religion scripture and put it at the seat of government, in my mind, violates the Constitution. But I lost that 5-4 in the Supreme Court. Thank you again so much for coming and for having me.